The Supreme Court has just struck down part of President Donald Trump's global tariff program. It was a key piece of his effort to shrink the U.S. trade deficit, but new numbers suggest the strategy may not have worked as planned. Last year, the gap between what America imported and what it exported hit a record $1.2 trillion. Now, that happened even with the highest tariffs in 8 decades in place. A new study from the New York Federal Reserve found the financial burden of those trade levies was shouldered almost entirely by American businesses and consumers, not by foreign exporters. The policy did bring in money, a lot of it. So far, Washington has collected $124 billion in tariffs. That's up more than 300% from the same period last year. That surge in revenue helped cut the U.S. budget deficit by 26%. But that financial boost may not last. With the High Court rejecting the Trump tariffs, much of that income could now be rolled back. From refunds to legal challenges, Deborah Elms, head of trade policy at the Hinrich Foundation, details the ripple effects that the Supreme Court's ruling could have on Mr. Trump's broader trade strategy.
This chaos on the U.S. trade front is set to continue, and it will especially affect Asian partners that have been negotiating with the United States on what were called reciprocal tariff deals. Those were based on the IEEPA decision. It's unclear now whether those deals actually fall or whether they're up to be renegotiated or whether they remain. Because under those deals, it says the reciprocal tariff, for example, on Indonesia is 19%. If IEEPA no longer applies, does Indonesia still have to pay a 19% tariff, or is that now invalid and they are also getting the 10% globally applied tariff? We don't know. And so the lawyers are busy scratching their heads trying to determine how the ruling might apply to existing trade deals, especially those here in Asia.
Right. We understand, of course, that President Trump has rescinded the IEEPA tariffs in that sense after the court ruling. But does the U.S. administration, though, still expect these trade partners to stick to their recent bilateral agreements with the U.S.? I mean, they hadn't renegotiated those terms.
It's clear that the administration thinks that they're still valid. And Bessent, in fact, the Treasury Secretary, said that he expects all trade partners to follow through on their commitments. I think there will be a lot of head scratching around trade partners who will say, well, wait a second, we negotiated this in one legal context, which is now declared invalid and illegal. We should surely at least sit down and discuss whether the entire agreement that we have negotiated is still valid or whether parts of it need to be renegotiated. Do we need to continue under the same auspices that we had before, or do we simply say we're not going to challenge Trump on this issue? I think there will be a lot of emergency calls happening over this weekend, especially by trade partners, to try to figure out, like, what are the steps that we're prepared to take? What kinds of questions do we need to ask? What kinds of steps would we need to take if we are no longer following these trade agreements? Remember that none of them are actually legally enforced yet. Parts of them are, parts of them are not. And so it's a really confusing situation in which there will be a lot of money spent on lawyers and consultants and customs brokers to try to unravel the mess that has now been created. Business likes certainty. And what we have done with the Supreme Court ruling is we have given a certain amount of certainty. IEEPA tariffs are not valid. But we have unleashed a whole new set of chaos because other tariff authorities, like this Section 122, which has never been used before in this way and will certainly be subject to a legal challenge as well, are now in place. And so that tariff uncertainty into the United States, I think, is set to continue. It's quite clear that Trump loves tariffs, and he is not going to get rid of his favorite tool just because the Supreme Court told him he can't use it under one specific statute.